let's say I create a generative AI internet application related to music. I do it for commercial purposes. And to train it, I scrape the entire internet of all songs, including every one of Taylor Swift's copyrighted songs without her permission. Your view is I wouldn't have to compensate her in any way. Is that right?
So in an instance where what you've done is extract unprotectable facts from any copyrighted work, so stepping aside and generalizing this point to any kind of work, if what you've done is extract unprotectable facts from those works and then use those facts to generate a new work, then under well-established principles of copyright law, that is not infringement.
I'm not even about generating anymore, I'm just about training the model.
Just on the training side, if that's all that happens, then under a long line of cases that I've laid out in my written testimony, that is fair use.
But to train the model, you need to actually download the Taylor Swift songs.
That's correct. That's correct.
And you view that as fair use?
That would be fair use. The premise of any fair use case is going to be...
So internet applications like YouTube pay a licensing fee to Taylor Swift when they download her songs. What is the difference?
Well, the difference would be in those instances, what they're doing is they're taking the work and then they're taking that work and they're streaming it to end users. So that's a public performance of her work.
Now let's say I take my model and I generate a new song similar to a Taylor Swift song in terms of lyrics. Is that a copyright infringement?
It would not be infringement.
It would not be infringement.
Because one of the basic principles of the Copyright Act, which I discussed earlier, is replicating somebody's style, writing a song. If I were to write a song in the style of Taylor Swift, I would not be committing copyright infringement. That's one of the founding precepts of the copyright law.
Now, as you know, voice cannot be copyrighted, but let's say my model also generates voice very similar to Taylor Swift, and I have this brand new song similar to Taylor Swift's voice, similar to her lyrics. You believe that that would not be copyright infringement?
I think as a matter of copyright law and just the basic principles of copyright law, that would not be copyright infringement.
Many creators already use AI, right, in their creative works. I mean, there's a whole bunch of algorithms that make your songs sound better. They don't disclose that. Like, how would you even define what kinds of AI they need to disclose that help them with their particular creative work?
That's a great question. If you'll indulge me, I want to answer your question to Sai as well. So that your question about if I download Taylor Swift's songs and I learn from it could be equally well posed to a teenage pop star who's learning how to sing. So if that person learned from Taylor Swift, the decision of whether or not they're violating copyright is not at the time when they're listening to the songs and learning to perform music. It's when they release an album and whether that album is sufficiently similar to Taylor Swift's song. So if we release instead of Taylor's, that's infringement, but the learning from it is not.
Is it unrealistic to think that the songwriters, the people, the American people, whoever, could kind of see what goes into these sources of what has an influence on the AI? Maybe Mr. Callison-Birch, I'll give it to you, but I don't think the average person, myself included, understands the technology. But is it unrealistic to ask that we know if a particular song got more influence from Taylor Swift or whoever, and how that process comes about?
Again, I want to make this distinction clear. What AI systems are learning from their training data is more akin to facts and patterns and statistical correlations than it is memorization or directly lifting from copyrighted works.
Is it a common industry practice to keep a careful record of how and whether copyrighted works, performances, and likenesses were used to develop or train an AI data set?
Thank you, Congresswoman. Yes, it is. In fact, there was a Washington Post interactive feature published about 2 weeks ago, sort of provocatively named "The Secret Lists of Websites That Make ChatGPT So Smart." That was produced in collaboration with researchers at AI2, where I'm currently taking my sabbatical. That lets you exactly search for which websites were included in the training data of a very common training set, not necessarily the one that ChatGPT uses, but the one that many people in our industry do use.
And just as a follow-up, do you think that would make it easy to devise a compensation system since we have that trail of what's been used?
That's a great question. So I think the tricky part about creating a compensation scheme is, once again, there are 1 trillion words worth of text in our training data sets. Each author represents a vanishingly small portion of that. We do not reperform any of the songs or texts that are in our corpus. It's not a performance-based compensation scheme that would be possible. So instead, it would have to be something to do with the volume of each person's contribution to that work. And again, I think if you do the math, it'll end up being everyone gets a check for 2 cents, which doesn't make sense.
We have similar things in the music industry, though. But I want to get on to my.
Those are orders of magnitude smaller.
Yeah.
Unlike compulsory licenses, which are based on performance, so the MMA, where Spotify plays music, Taylor Swift gets more money than some random person in the catalog because her songs are played more. There's no equivalent here for generative AI. It's impossible to understand how much of a system's output is due to Stephen King versus a random Reddit poster who's written a paragraph in the collection. So I think the lack of that performance is key to one of the tricky things about establishing a compulsory license here.
Let's say that I'm writing an essay on Abraham Lincoln and arguing how he ranks among U.S. presidents. So I go to the library, I check out every book I can possibly get on Abraham Lincoln, I learn all about him, and then I reach an opinion and I write an essay about it. And of course, I'll cite to sources when I'm quoting them directly or for specific facts. But that learning process by which I form my opinion, this is for you, Mr. Damley, is there any copyright claim that is specific to that process?
Yes, you're producing an output that might borrow and those facts into a new work, but that work does, as long as that work does not infringe the original work that you copied from, that's quintessential fair use.
And so a court that would sort of study any copyright claim, would they look at my learning process, or would they just sort of judge the output? Maybe they would if it's like about intentionality or a damages claim or something, but the core copyright claim, infringement claim itself, would they study my learning process, or would they just look at my work product?
These copyright cases, having litigated a lot of these, really delve into a lot of the facts. So the Google Books case, for example, that looked at the way in which, the manner in which Google had acquired the copies, but then the outcome was driven mainly by the fact that all that Google was doing was providing a way for you to search within those books, and not providing you the whole book, was providing you just snippets of the book, and said, looking at that whole process, we're going to call the copying and retention of the copies for that end purpose to be fair use.
Interesting. And so one of the things that Mr. Altman said is that he thinks we're moving towards a stage where really most of the training is based upon synthetic data that's generated by the AI itself. Maybe an analogy to this is sort of when DeepMind was training its Go playing AI. At first it studied the master's games, but then it's eventually just learned how to succeed by playing itself. So does that impact the analysis? This is for either you, Mr. Domway, or Mr. Callison-Birch. Do you have thoughts on that?
This is a very interesting question. So I've done a thought experiment regarding to training AI systems on completely synthetic data. So after having been a panelist on the US Copyright Office, listening to her, I thought about what about our training data do we need in order to learn the facts about the world that we care about and learn the language patterns? So we need examples of language in order to learn the structure and grammar of language, and we need some anchor into how people discuss the world in order to learn facts about it. There's no obligation that be human written text now. I think that in my little armchair experiment, we may have reached a copyright escape velocity where in theory you could have a system like ChatGPT generate 1 trillion words worth of text, which current copyright would be not copyrighted, and then retrain a subsequent system where you throw away the original one entirely. It's not derived from copyrighted works at all, but it still is likely just as performant as the original.
So yeah, and my time is up, so I'll just say in closing, I kind of worry that many of the issues we're talking about here might sort of be obsolete within a matter of years, especially as the capabilities of these systems advance.